Colin Township versus Alfred Joder and Joanne Joder. We had a hearing on September 24th, and the court made some rulings. Mr. Thornton submitted an order. Frankly, Mr. Thornton, I don't know what happened to it. Some of the circuit court filing things are a mystery to me. We had trouble finding things today. We were looking for, I know you'd filed an affidavit of cost, but I couldn't find it. We did finally find it. Anyway, I got this order. It's not date stamped. But you filed it shortly after the hearing, I think maybe on the 30th. We'll address that in a minute.
It's on September 3rd.
All right. It's not date stamped, but we think we discerned that. All right, that's an order following the civil contempt hearing in 25040CZ. That's what we'll refer to as the birthing center. In the adjacent building that was subject to a stop work order, that is filed 25533CZ. I entered a permanent injunction on that day. I wrote the 23rd, but it was the 24th. In that case, the defendants filed some last minute briefs in that matter shortly before the hearing. I think they were bench filed on that day and they weren't addressed. And I said I would address those hearings today. Mr. Thornton has filed a responsive brief. Then yesterday, I saw the defendant's associate here at the courthouse, and we said hello. And I surmised that she was here at the 11th hour filing some filings again. And they never told me, so I called the clerk's office this morning to say, did they file something yesterday? And after some searching, I was advised that they did. So they filed more things effective yesterday in the 040 case and the 25533 case. So let's set aside the adjacent structure 25533 for a moment. We'll come back to that. I'm going to sign the order that I should have signed a month ago or weeks ago. I'm going to sign it effective 15th of October, granting the relief I ordered on the 24th. Would you please make 2 copies of this, one for Mr. Thornton, one for the defendants? All right. We've got a couple orders of business, and it's hard to try to keep everything straight. After I made my rulings on the 24th, the permanent injunction default that had entered remained in place. Mr. Thornton requested a fine of $3,500 per defendant and cost for the township. He was true to his word, and he filed an affidavit of costs, setting forth the cost that his office and the township had put into this matter. We'll address that in a minute. On October 6th, the Joders filed a filing package for the October 15th hearing. And the problem is it mixes the 2 cases together. It's got 25040 and 25533 penciled in. So the 40 case has just to do with the birthing center. One of the documents here actually does have some relevance. Motion for reduction or admission of fines. This court has scheduled a hearing to determine the civil contempt fines. That statute authorizes the court to mitigate or discharge any fine where a party has purged the contempt and complied with the order. Defendants have ceased construction and abandoning the birthing center units and now seek lawful residential permits. Continuing to impose large fines serves no remedial purpose, will be punitive and excessive. Defendants ask this court to exercise its discretion to reduce or remit all civil fines and close the contempt matter. That's the most relevant pleading I've actually seen in all the pleadings. So Mr. Thornton requested a substantial fine and costs. As we know, you've each posted a $1,000 cash bond with the circuit court for failing to appear for one of the hearings. Judge Stutsman ordered a bench warrant with the bonds, and you posted the bonds, and the matter was continued, and I've been holding those bonds since. So the first thing we're going to do is address the issue of the fines and the costs. I'll hear from Mr. Thornton first, and then I'll give you a chance to respond. That pleading actually was pretty good. The law is different in zoning matters. In most cases, most criminal cases, if you're charged with a crime, you don't generally have to pay the cost of the prosecution. There are some exceptions that specifically allow for the cost of prosecution. And if you were charged, for example, with driving suspended under Sturgis City Ordinance or 3 River City Ordinance, and they had a trial, and the prosecutor spent $2,000 preparing for the trial, you don't have to pay for that. They don't get to ask for costs of somebody having a trial in the matter. People have a right to have a trial in the matter. So they shouldn't have to pay a premium for it. As I indicated, there's a couple of statutes, drinking, driving, and some others, which allow the court to order the cost of prosecution, but it's very rare. However, in zoning matters, the cities and villages and townships will often ask for their costs. To do zoning enforcement costs all the people in the township. So Mr. Thornton has asked for a fine, and he's asked for costs. So Mr. Thornton, at the close of the last hearing, you asked for a substantial fine as to each defendant. Would you like to speak to that?
Sure, Your Honor. The statute for contempt, the section 600.1715 is one that addresses the fines and allows for up to $7,500 per defendant. So in my discussions with township officials, we came up with the request for $3,500 for each defendant for a total of $7,500. As far as the fines, the
3,500 times 2 equals 7,000.
7,000. Sorry, but that is correct. 3,500 each times 2 for the 7,000 total. The township's restitution request is based on 600.1721, payment of damages essentially caused by the contempt that the defendants have found to have committed against the court orders. And that's, as I read it, mandatory. The court shall order the defendant to pay such person a sufficient sum to indemnify him. When I submitted the affidavit of costs, it only sets forth costs that I believe relate directly to the civil contempts and the additional costs that the township incurred. because of the civil contempts and the failures to appear. So that even though it's a substantial amount, that in the affidavit of cost of $3,885.50, that certainly does not even come close to what the township has spent in case 040 to get it to where it's at today. So I leave it up to the court. It is the court's discretion on the fine. But I do request the restitution to the township as to the affidavit of costs, and in addition to the motion, let's see, the taxable costs that were incurred, all set forth in the affidavit of costs. So so as I calculate those, there's $3,994.46, all accounted for in the affidavit of costs. There is $265.48 in the cost ordered in the default judgment in case 040. And I'm requesting an additional $190 in cost for responding to defendant's filing package in case number 040. And I believe that's the recent one Your Honor was mentioning.
Those October 6th one are the ones we got yesterday.
No, that doesn't, the October 6th ones.
All right, so is that 190 in your bill of costs?
It's not, Your Honor, because it came in.
You did put in an hour estimated for today.
For today's hearing,
All
but
right.
that 190 is just responding to that motion on October, that what they call a filing package.
Yes.
On October 6th. And there was one filed in each case, and that's just for the 040 case. So that totals for 040 case, $4,449.94.
All right. Thank you. I knew you had prepared it. I had a heck of a time finding it, but we did find it. It was date stamped the 30th. I don't know how they do things in circuit court. When a motion is filed in my court, I'm given a copy of it. They just, maybe it's because I'm a district judge by assignment, it just gets stuck in an electronic file. The original is destroyed, although I was managed to save the originals from yesterday. And then it just goes in the file and they don't say, hey, this got filed, or I guess, I don't know if he looks in every file every day to see what got filed, but anyway, it's a system that's different than the one I'm familiar with, but I knew these things were out there. All right, Mr. and Mrs. Yoder, I tend to agree with you that you are in compliance with what was originally ordered. You don't necessarily like it, but you've accepted the inevitable. You've ceased to operate the birthing center, at least at that location, and you stopped construction on the adjacent building on the lot next door. We're going to talk about that case in a minute. And to assess a large fine of $7,000 on you and your family seems to me to be overly punitive. And as Mr. Thornton mentioned last time, the township doesn't get the fine. It goes to the court and to the state of Michigan, and the court has discretion in the fines. As he indicated, the statute doesn't give so much discretion regarding these taxable costs. The statute says the judge shall assess those costs. That's 600.1721. So I don't have a lot of discretion. Mr. Thornton has a billable rate, which is lower than many attorneys, certainly in a larger city. This was a Detroit law firm, or even Kalamazoo or Grand Rapids. That hourly rate would be substantially higher. And truth be told, he probably has more hours into it than is on the billing. Also, this is only his cost as to the contempt portion. The matter was set for hearing in front of Judge Stutsman. You didn't show up. There was a show cause. You didn't show up. A bench warrant issued. And then sometime after the bench warrant issued, Judge Stutsman asked to recuse himself and asked me if I would take it. So this train was quite a ways down the track before I got on it. But I'm going to grant a cost as assessed by Mr. Thornton in his bill of costs. But before I do that, I guess I ought to give you an opportunity to be heard on that. I'm not going to assess any fine. But he's filed an affidavit of costs. And do you wish to respond to that?
Negative.
All right.
Yeah,
Yes?
so, I object because we are already complying to good cause. So why should we be punished with a fine?
Well, I don't necessarily disagree with that. So I'm not giving you a fine. They asked for $3,500 a piece and you are in compliance. So I'm not ordering any fine. What I am ordering is that you pay the cost of what the township had to pay for your failure to appear and all the contempt rigmarole that we went through. As I said, that one was well pled. So I'm granting plaintiff's request. It's in the bill of costs for attorney fees of $3,885.50 plus $190 for responding to the October 6th motion. Plus taxable cost of $108.86 plus the earlier costs of $265.48. If we add all that up, it adds up to $4,449.94, offset by the $2,000 bond. Which leaves $2,449.94 due within 30 days. That is just cost. There's no fine. All
I
right.
did prepare an order, Your Honor, but I'm not sure, it doesn't really take into consideration the 2,000 from the bonds. But I don't know if Your Honor wants to
Well, can I
review
look
it
at-
and mark it up. Or...
Yes, let's try it.
Two paragraphs on restitution, one for each defendant, and two paragraphs on fines, one for each defendant. Obviously, under the court's ruling, the fines would be 0. And then I set it up so the restitution would be divided between the two defendants, since there are two defendants.
Well, I'm going to do it joint and severally. $2,449.94. The total amount is $2,449.94. It's not twice that. And you're jointly and severally liable for it. If Alfred pays the whole thing, that satisfies Joanne's obligation. If Joanne pays the whole thing, it satisfies Alfred's obligation. If you each pay half, it satisfies your obligation. So the total amount is attorney fees, the previous court costs, and the related costs, jointly and severally. They don't get to collect it twice.
Your Honor, is the order reflecting that the $2,000 bond is also going to be forwarded to the
Yes,
township?
thank you. $2,000 cash bond. 1,000 per defendant. Well, it's already been applied. Was applied. To total of $4,449.94, 44994. So the total, I better change that. 4,000. Maybe clean this up. 4,449 less $2,000 cash bond. So each defendant owes $2,449 jointly and separately. All right.
So does the order reflect, and the clerk's office will know to forward that $2,000 bond to the township?
Shall be forwarded to the township. Thank you. That'll make it more clear for them. All right, so that's the issue regarding costs and fines in the birthing center case. Defendants filed some last minute motions just before the hearing and filed more motions yesterday. Mr. Thornton filed a response to the filing package filed October 6th. He filed that the very next day on October 7th. One of the problems is the thing had both case numbers on it. So it was hard to discern it, but you're asking to modify or clarify the permanent injunction. I didn't really understand all of it. Equity and change circumstances, statutory authority, due process of public authority concerns religious and cultural context. I had already determined that Judge Stutsman's default order would stand because the defendants had failed to move to set the default aside in a timely manner. Then after we have that hearing, they filed this on October 6th. Mr. Thornton objects to that on multiple grounds. So Mr. and Mrs. Joder, we've got your October 6th motion and we've got your new motion filed yesterday. motion and brief to recognize compliance, set aside default judgment, and for equitable relief. I'd said this several times. Yes,
That one that was filed yesterday
yes.
was filed yesterday because we got Lance's love letter Saturday and nothing was open Monday. So we had to wait till yesterday to file it. That's why it was filed last minute.
All right, well, I'm not aware of any letter, love or otherwise, from Mr. Thornton, but trying to be diplomatic here. I said from the outset that I first got in this case that you needed a lawyer. At one point, apparently you had one, Mr. Marvin, and I don't know, that didn't go very far. I'm not sure what happened. You got advice from people that aren't lawyers. And in essence, they're practicing law without a license. And most of the advice they gave you was bad. You ended up almost going to jail because you took advice of people that don't know what they're talking about. You got bench warrants issued for me from Judge Stutsman. You may well have had some defenses to these matters. My sense of you folks is that you're honest, hardworking Christian people that wanted to provide a service that people want. There is demand for your birthing center, and you have a great community support for that effort. But you can't do it where it is. This wasn't my idea. This is how it came up. In fact, I'm still dumbfounded that there's not some sort of state licensing or something for such a facility, but that never came up. That you just wanted to do your work and have everybody leave you alone. And frankly, most people probably feel that way. But you can't do what you were doing where you were doing it. Judge Stutsman had made a finding of default and he entered that order. So I was operating from that order, but they heard maybe some testimony about problem births or other things I don't know. My son would have died if he was at your birthing center. He was an emergency C-section and they called Dr. Don in the middle of the night. He came to Three Rivers and did a C-section on my wife because he was a frank breech. Those are decisions I don't have to deal with because this judgment already entered. So people want you to provide this service, and maybe it can be somewhere that's close to other hospitals or facilities if there is an emergency. But all this stuff that gets filed at the last minute, the day before the hearing, it's not captioned properly, it's not signed properly, it cites stuff that isn't legal authority. You've been taken advantage of by people that are well-meaning, but they don't understand what they're doing. That's to your detriment. So you filed these motions. All right, first, let's talk about the October 6th motion. Yes, Mrs. Yoder?
So when we was here to meet you first, you gave us the rights, I've wrote a note here for me. You had said that we can respond in any way, handwritten or anything, where we being judged and how we respond.
Yes, you can. It isn't very effective. You're sincere about it, but you don't. The law is complicated, and you're all here witnessing that. It's complicated, it's cumbersome, it's expensive. And you're doing the best you can, but your responses don't comply with the court rules and don't constitute a defense to the township's action. I'll repeat myself for about the 10th time. Judge Stutsman ordered a default judgment. You didn't show up for the hearing. They had a show cause hearing. You didn't show up for that. Bench warrants issued for your arrest. So that order was already issued. Now you're asking me to set aside the default on October 6th, and you're asking me to set aside the default again on October 14th. That ship has sailed. So maybe I don't understand your pleadings well. In fact, I'm not sure you understand them well. But let's talk about the October 6th pleading. What are you asking me to do?
Let me finish my building. As a
Yeah, well,
residential,
we're gonna get to that one in a minute. That one, that's legit. That looks like a nice, well-built building that could have a purpose. Right now, we're just dealing with the birthing center case. We haven't gotten to the building case, but I went out and looked at it, and it looks like a nice building, and it could be something that you could utilize. You've got tens of thousands of dollars into it in material alone. So we'll see if we can come to an answer to that question. But right now, we're in the other case. When I got this, I thought, well, I'm gonna have to follow this to the end. And we got to figure out what to do with that other building. And we'll try to address that here in a minute. All right, Mr. Thornton, any further response to the October 6th filings?
Yeah, Your Honor, in reviewing all this, and it gets confusing for me too to deal with all the filings, but to my knowledge, in the 040 case, there was not one motion set for today for hearing. There was no notice of hearing ever served upon me and my office. To my knowledge, there was never anything scheduled.
Well,
or
I had
agreed upon
scheduled the last minute motions in the
in the 533 case.
533 for today. Yes,
Correct.
okay, so
I agree with that.
this one says 040, but it wasn't noticed for anything.
Correct.
All right.
And I guess what I'll state is the Joders are arguing that they've complied. I'm not sure that's clear at this point in the 040 case. And one of my responses, I did make the court aware that the babies are now being born on Mountain Road, and then mom and baby are transported to 30100 Marsh Road, the Joders property. That's the subject of the 040 case for.
I object to that one.
Well, that's not testimony, so I guess you can't object.
And this is based upon information and belief, information I'm getting out of the clerk's office from birth certificates being filed there, and secondhand information that the township's getting from witnesses. So
Where are they being born now?
Mountain Road, in a home on Mountain Road.
Is that in Colin Township?
It is. And then the information we're getting is they're transported over to the birthing center and for aftercare and a stay there until they're ready to leave.
Well, I don't know the answer to that one. I don't know. Maybe we aren't done with this case. I had hoped that we were.
I'm not asking the court to address that. I realize that's gonna have to be addressed in the future. But the Joders are basically arguing that we've complied in 040 case, and therefore the whole default judgment, permanent injunction should go away. And there is just no legal basis for that argument that we complied. Therefore, the judgment and permanent injunction should go away. Certainly, as they have done, and the court has recognized that was an argument for reduction or waiving of the fines, but not to set aside as they've requested the default judgment.
All right, I have heard their plea in the motion for reduction or remission of fines, which essentially I granted in full. The motion to set aside the default from the October 6th motion is denied.
Your Honor,
Yes,
I object to that. September 24th, we were asked to give no care to pregnant women at 30100 under lots of stress. We have faithfully followed the court order. It is heartbreaking that our elected township has become so distressful that a simple family gathering or visit from friends and relatives are treated as a violation. We have a pregnant daughter and pregnant daughter-in-law who cannot even come to our property without being stalked or accused of breaking the law. This is not justice. This is prejudice. We hope these watching and listening today will see that we are peaceful people trying to do what is right. Please help us restore the fairness and stop this unlawful behavior by township. We have shown good faith and asked for good faith in return. We've done everything the township has asked. We're compliant, we're peaceful, and yet we're still treated like offenders. This is not how community or justice should work.
well, thank you for that. I haven't found that you've done anything else in violation. What you just told me is all news to me, just like what Mr. Thornton represented. You certainly should be able to have your family members come to your property, but that's not before me. I'm not finding that you violated anything else. At this point, I'm taking you at your word that you've stopped using this as a birthing center. So that October 6th motion is denied. Yesterday, and this is one I had to track down. I saw your associate here and she was cordial, and she had something in her hand and I thought, well, did she file more stuff? And it took me till about 10:30 this morning to actually get it. But this one is entitled, it's in 25040. It's entitled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Regarding the October 14th motion, the one that was filed yesterday, and you said you got some sort of letter from Mr. Thornton on Saturday. Don't know about that, but what are you asking me to do in yesterday's motion?
What can we do with that building?
Well, that's in
No.
3535. What can you do with the
Mama's
birthing
house-
center?
the Mama's house building. Because as it stands right now, the way I understand land, you can't do anything in that building.
Well,
We've got our belongings in there. I mean, it's freezing.
well, you can, I don't know the answer to that. I don't know if there's more than one structure on that property. There's a house and maybe an adjacent house and then the birthing center. And I don't know the answer to that. Can you reside in it? Can you have a prayer meeting in there? Can you?
Well, prayer meeting would be allowed by Colin Township.
Your Honor, can I address that?
Yeah, I guess so.
The township's position has never been, and we've never told the Joders that they can't use 30100 as a residence. That's what it's built as. That's what it was designed for. And they can certainly continue to use it as a residence. Colin Township zoning ordinance allows 2 residences on 1 parcel. So the Joders' home at 30158 and the Mama's house current what was used as the birthing center, 30100, are on the same parcel. So they can use both as residences. Township's never taken the position that they cannot use both homes as residences. But the court order is very clear, and the default judgment, permanent injunction are clear that they can't use 30100 as a birthing center. So different from a residence. So I'm not sure where all this is coming from, that they can't do anything with 30100. It can be used as a residence.
Well, all right, fair enough. That answers that question. And
Yeah.
again, it's too late to set aside the default. You're asking for equitable relief. Equity permits relief from judgment if it would be unjust, inequitable, or contrary to the public interest. Again, this order has already entered by default. And the defendant didn't move to set aside the default in a timely manner. So if there was no injunction and you were living there and your daughter and son-in-law lived there, or whoever lived there, that's completely within the recognized use in Colin Township. And the things that you can do in your own house, host Christmas, have a prayer meeting, have your grandkids over for the weekend, the kind of things anybody does in their own house. Those you can do. You can't operate it as a birthing center. So the motion for equitable relief and set aside the default are denied.
Yeah,
Yes,
I just want to clarify the situation on as far as the 30100, because the way I understood in the last hearing, that it was made very, very plain that absolutely nothing to do with pregnant women. And
Well-
that's why I was very concerned about.
well, let's take a look at Judge Stutsman's order. Default judgment and permanent injunction.
Actual order starts on page 3.
The above findings of fact are hereby incorporated and made a part of this judgment. Colin Township's request for adjunctive relief is granted, and the defendants shall cease operation of the birthing center on the Joder property as soon as reasonably possible. I think we settled on September 1st or 3rd. Defendants and their agents, service, assigns, and successors in interest, or anyone in active concert with participation with the Joders with regard to operation of a birthing center, are permanently enjoined from operating a birthing center on the Joder property. Colin Township shall cause a certified copy of this judgment to be recorded with the officer of the Register of Deeds within 30 days of the date of this entry. No money damages awarded to Colin Township. Defendants are ordered to pay $265.48 in taxable costs. All right. You raise a legitimate question. There's no definition in here of what is a birthing center. The presumption is a birthing center is a place where people go to release their confinement and give birth to a child. If the children are born somewhere else and then come there, not sure what that is. That's a daycare center, but the birthing center is not defined. So your request for clarification probably has some merit to it. The order doesn't define it. I don't know that it did otherwise, but a birthing center, let's take it at its plain meaning. It's a place where people come to give birth. And you have a large following, you had more births of that birthing center than probably both Three Rivers hospitals combined, Three Rivers and Sturgis Hospital combined. More babies were born in St. Joseph County at your birthing center than anywhere else. Most of the babies here are going to South Bend or Elkhart or Kalamazoo, Coldwater maybe. So you can't have births there. Can you have children and mothers come there after they give birth? I don't know the answer to that. The township, if you do that, the township is going to ask for further relief. My hope was you could find a place to put this that would comply with zoning, either in Colin Township, in LaGrange County, in some other township, and then continue to provide your service. Frankly, that's what I hope. You've got people that want to use the service, you want to provide it, but you can't do it here. This just keeps poking at the sore point. So all I can tell you is what the order says. That you're not to operate a birthing center on that property. Mr. Yoder?
We are looking into buying other property in a township that's got a little more brain.
All right, well, I don't, like I said, there's a demand for your service.
Well, it's obviously, yeah.
So that would, I don't, that's what I hope happens. I hope you find a place to put this where it can be licensed and everybody's in agreement and you continue to provide a service that people want.
We have 2 townships that are begging for us to come their way.
All right, well, more power to you. All right, so that resolves the 2040 case. The injunction remains in place. You're not to operate as a birthing center. I have offered costs. I've ordered costs as they requested with Mr. Thornton's bill of costs. I've denied your motion of October 6th to set aside the default. I denied your motion of October 14th to set aside the default. So as far as I'm concerned, that case is done once you pay the balance of the costs. And that number is $2,449.94. Mr. Thornton, would you do an order denying the defendant's requests of October 6th and October 14th?
I will, Your Honor.
All right, let's go to the adjacent property. In the 25539 CZ, I could tell that this was going to be a problem that would need some further attention. As I said, I went out and observed it. So I did an order on August 29th, granting the preliminary injunction. Then on September 24th, I entered the default judgment granting the permanent injunction. And that had to do with a stop work order on that property. Now that order is dated, I wrote the 23rd of September, it was actually the 24th. Orders. The defendants, their officers, agents, service employees, assigns, and successors are permanently enjoined from performing any further work on the interior, exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by the plaintiff's building code officials and stop work orders that have been issued and posted. occupying the building. You're enjoined from occupying it or allowing anyone else to occupy it unless written authorization is obtained by the building code officials. That's commonly known as an occupancy permit. C, if an occupancy permit is granted for the building, using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and pregnant women as a place to give birth for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. So if your daughter or daughter-in-law live there and they have a baby there, that's within their rights. All right, so right now, there's a stop work order until it's approved by the zoning officer. And the township would grant permission to turn it into a residence because that's what it's zoned for. So that's the order that was in effect from September 24th. So you filed some motions immediately before that one that I didn't have time to address. So I set those for today. You bench filed on October 24th. Excuse me,
Actually,
September 24th. I'm not sure what this is called. Defendants respectfully move the court to dismiss the above captioned action for lack of jurisdiction, due process violations, and the township's failure to present a lawful case. This action is built entirely on defective proceedings where no proper sworn witnesses testified, no valid authority was demonstrated, and the attorney for the township improperly acted both as advocate and de facto witness. Again, a default entered. There was a temporary injunction that was then granted in full on September 24th. This is bench filed on September 24th, like 1 minute before the hearing. I didn't have time to address it. It's not signed. It isn't titled, but I guess I'll entitle as a motion to dismiss. Mr. Thornton filed an answer to that a few days later, objecting, arguing the motion is not signed. The motion does not need to meet the filing standards set forth in MCR 1.109D. The legal brief was not filed with the motion as required by law. And the defendants have not moved to set aside the default judgment entered in this matter. They simply asked me to dismiss it. While the motion appears to claim that the court lacked personal jurisdiction over the defendants and subject matter jurisdiction, the motion fails to set forth any facts or recognize legal argument to support a claim of lack of jurisdiction. Instead, the motion attempts to raise defenses to the township's claims set forth in his complaint that the defendants could have raised had they filed an answer and participated in deciding the merits of the township's claims. That happened in both cases. You got sued, the lawsuit was served on you, and you never filed a timely answer. So in each case, you got defaulted. And in each case, you didn't file a timely motion properly to set aside the default, where you have to state legitimate reason for not responding to the summons and complaint and file an affidavit of meritorious defense. On all of those matters, you could have been helped by an attorney that knew what they were doing. So Mr. Thornton asked me to strike the motion in its entirety due to the fact that it's unsigned, strike the motion entirety due to failure to comply with the court rules governing the motion, and deny the motion in its entirety.
Your Honor,
Yes,
which one are you talking about that we didn't sign?
this one, bench filed on September 24th. Let's see if it has a date on it.
I don't believe it does, Your Honor. It was undated and unsigned.
So I'm gonna strike that one. Plaintiff's request to strike that unsigned motion is granted. Mr. Thornton, I'll ask you to do that order too. Then this morning at 10:30, I got your newest pleadings. They were filed yesterday afternoon at some point. They're date stamped October 14th. And again, I had to go seek them out. It's titled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Now, there's also a brief in support of the motion to recognize compliance, set aside default, and equitable relief. This has to do with the adjacent house, which would make a very fine house, I guess, if we could turn it into a residential property. You're not the first person to be frustrated by dealing with zoning officials. Some are more strict than others. Some township zoning rules are stricter than others, and they're all stuck with the proper building, electrical, plumbing, mechanical codes that require things be done in a certain way. Those zoning officials are not elected officials. They don't swear an oath. They're hired as an independent contractor by the township to handle the zoning and construction code matters. So again, I didn't see this until this morning. I was busy with other stuff. I shut my door at 10:30 and tried to make sure I could digest all this. So I worked through the lunch. So it's your motion. Either Mr. or Mrs. Yoder, what do you want me to know about it, your motion and brief to recognize compliance, set aside default, and equitable relief? The one that was filed yesterday.
Oh, can we get the injunction or whatever lifted and get the building permit so we can, maybe I can at least live in a mansion if I can't use it for anything else?
I'd
I
like,
mean, it's already zoned residential.
yes, I'd like that.
Well,
Uh,
I applied for a building permit already like the 6th. And according to Lance, Safefield is trying to work with us. Something about the permit, but they've never called me and never sent me any letters or anything. I called twice and nobody answered. But they're trying to work with me to get more information.
All right. Mr. Thornton, apparently what they're really seeking is to figure out how to bring this building into compliance.
There's absolutely nothing that needs to be done, in my opinion, to the default judgment and permanent injunction in this case, because as we went through a few minutes ago, it lays out what needs to be done. And the Joders have taken the very first step to do that. I have confirmed with Safebuilt that the Joders did get an application for a building permit and recently filled it out, as Mr. Joder says. I believe, not sure if it was October 6th, but it was very recent, in the last few days, a week here. And that was filed with Safebuilt, and the fee paid. But they have not obtained a building permit. It's my understanding from my discussions with Safe Built that the Joders need to modify the plans, which were for a birthing center, to show that they're for a residential structure in order to get the building permit issued. So that's where my comments that, and I've directed Safe Built to work with the Joders, but I highly doubt they've had time to, if there are letters that have been sent, which I don't know if they have been or not, they may not have been received yet, but I know there's an issue with the building plans that need to be revised or added to, supplemented in order for that building permit to be issued. Once that is issued, then they'll have inspections. And if the inspections pass and it's approved, I would assume there'll be a certificate of occupancy granted for it to be used as a residence. And,
It would make a very fine house. You call it a mansion. I don't know about that, but it looks like a very nice home. Now, homes get built all day everywhere here in St. Joe County. As tedious as our building and zoning codes are, could be worse. I read this week, it takes about 7 years to get permitted to build a home or a building in California. So they stop building anything because they can't comply with all the code restrictions. So they don't have enough houses for the people that want to live there. So people become homeless and the prices go up to unaffordable rates. We don't want that. In the gubernatorial campaign, both candidates argued that they wanted to reduce restrictions and red tape so people can get things done commercially. Heaven forbid, if you're trying to do some commercial construction, can be very cumbersome to meet all the code requirements. But all day, every day, somebody's building a house here in St. Joe County. And many are Amish built houses, both in Colin Township and all over the place. They're some of the finest carpenters around. So they know how to do it. And they know how to do it to get it permitted. I don't know who drew your plan. It doesn't look like somebody just showed up and said, hey, look, let's put this building up. It looks like it had some sort of coherent plan. And are there all the other issues that go with it? Plumbing, electrical, mechanical. I don't know if this township has radon abatement or other things that often go into construction, but somebody drew a plan. And somebody needs to redraw it to make this into a residence.
Your Honor,
Yes,
I don't see any necessity of redrawing it because this plan, I drew up the plan to make it suitable for my likings. And that is exactly how I want my house. I wouldn't change a wall. It is exactly what I want for me and my family.
all right. I don't know what the plan looks like.
It's my dream home.
Okay, then we need to get on the same page. And let's say it's a weird central kitchen area with 9 bedrooms off to the sides. If that's your dream home, I don't know. I don't know what it looks like on the inside. So at this point, you and Safe Built haven't really got down to the nitty gritty. So you're saying you would live in this as a residence just as it's designed now? Is that yes?
Yes.
Well, the same thing. I'm gonna deny the motion to set aside the default. These defenses, I guess, could have been raised earlier. The equitable relief you want is just to be able to use this building for your purposes. And I don't have any objection to that. I don't know that I need to grant an order granting you equitable relief. The problem is I'm probably gonna have to continue to hear this to shepherd this project through. I would be delighted if Safe Built came out and said you could do this, this, and this. These are the electrical requirements, these are the plumbing requirements. The inspectors came out, approved it, and it was built. You could live in it, have your grandkids stay there, but it would be a residence. So I don't deny your motion for equitable relief, but I don't grant it either. Meaning, if you are meeting with Safe Built and you don't feel that they are giving you what you feel is fair and equitable, you can ask me to hear it. In the context of this case, you can file a request for relief. But my hope is that you got builders that know what they're doing. You got plumbers that know what they're doing. You got electricians that know what they're doing. That we can get this built. Winter's coming. It has a tight roof on it, but it needs to get sealed up. So, Mr. Thornton, are you represent that Safe Build is ready and willing to meet with the Joders to try to make this into a residential property?
Sure. My understanding, Your Honor, is that the plans have to meet the building code for a residence. And that's what's holding up the process. Mr. Joder, when he went up and filed the application, and I'm getting this secondhand, was very rude and not to the Safe Built personnel and wasn't interested in sticking around. He just filed it and left. So
Well,
they're gonna, and I've instructed Safe Built to work with the Joders and to communicate with the Joders
I
as to what
object,
they.
sir.
well, you object that he'd asked Safe Built to agree to work with
I
you?
walked in there, I had the application and the check, and she looked at it. And I said, I don't remember exactly what I said, something about a building permit application, and she looked at it and she said something about the check ain't got nothing to do with this or whatever, but she can just hold it with the permit until it gets approved or whatever. I said, no, I'll just take the check with me. And I left. I guess I don't understand what this rude
Well,
crap is
all right,
about.
you're gonna have to talk to each other.
If you wanna know what rude was, you should have heard the electrical inspector the first time he was out at our place.
Well, everybody is going to have to,
I object to that one.
all right, well, you can object, but you're gonna have to, you don't speak the same language. I don't speak electrical. I don't speak plumbing. I barely speak English and sometimes I speak legal. But they've got certain, now, I don't know what this plan is. I don't know if it has 12 bedrooms and 1,800 square feet. You can't do something like that. And if it has 9 bedrooms and 1 bathroom, you can't do something like that. So they've got certain requirements from the state of Michigan regarding building codes on what needs to be done. So you need to try to do this within the confines of the Michigan building codes. And they need to work with you to try to get to that point. Yes, sir.
Right, so they had issued a building permit to start with
Yes.
as a resident, so as a residential house, so
Yes.
that floor plan is approved for a residential house.
That's an interesting point. They had at one point issued a building permit on that plan. What's your response to that?
Your Honor, my understanding of that is that the structure is over 3,500 square feet. And requires under the building code, when it's over 3,500 square feet, that the plans be drawn by an architect because of the size of the structure
Oh, boy.
and approved by an architect. That's in the Michigan Building Code. So my understanding is Safe Built incorrectly initially approved those plans and then went back and asked for, pursuant to the code, architecturally approved plans. Those, after a very long delay, the Joders did submit architecturally approved plans that were never approved because those architecturally approved plans did not meet certain code requirements, and a letter was sent, but nothing's ever been followed up with to correct what needs to be corrected in those plans.
Well, they need to do it, and there needs to be some accord, some flexibility to try to get here. Yes, sir?
Yeah, I like how he worded that. After a long period of time, we finally submitted our plans. Well, if you know anything about an architect,
Yes.
you contact the guy about getting a building drawn up, you're gonna wait your turn,
Well, I've been there.
all right?
I'm
So
there
that's
now.
exactly what I waited on. Now, if you want to turn that table backwards, we submitted those architectural drawings in October.
Of 24.
Yes. No, 23. Supposedly, I mean, like the dummy I am, I had my architectural drawings in there, so I wait on the officer to let me know what's gonna go on with it. From October till March. Finally, in March, I get a phone call that I owe them $2,833, I think it was, to have this drawing approved. That's the first I ever heard anything. The day that that check was cashed, the print was denied,
Same day.
same day.
And
And
So
then-
that-
and
that's
that's-
sort of a waste of $2,800
Oh,
and some
I think
dollars.
it's gonna get you to where you need to go. So nothing has happened on this since.
No, I
March?
dropped that part because it was red tagged and you couldn't work with safe fill, you couldn't work with plants. He's gonna stop everything. So,
Well, we need a different mindset. We need a mindset. No wonder you're frustrated.
Yeah.
Um,
There's one thing I would like to ask for.
Yes,
We just want to, no more questions, no more answering any questions. We want to reopen this case and
I'm not sure I understood that.
we just want to just be able to reopen the case and we're getting help.
All right, reopen the case to run a birthing center there,
no,
reopen the case to build a house.
yeah,
Well, it's never exactly been cold. All right,
no,
you can't run a birthing center in this structure
no.
on that lot. You can turn it into a residential dwelling. And
The reason I'm just saying this is because there's never any ending meeting like with Safe Built in the township, because just like when they said that we need to get an architectural drawing. Okay, my point was if they missed that and they didn't make sure that we have an architecture drawing at the beginning when we filled out
Yes.
applications, they should have seen to that.
yeah,
Square footage is
Before.
on every permit we've
well,
got.
apparently they
Before
issued the
we got-
original permit in error.
So,
So, all right, so you went out and got an architectural drawing.
but that wasn't easy because an architectural drawing, architect wants to make a drawing before the building's there. That was tough, finding someone that's going to do it, and every one of them, they're like, this is the dumbest thing they've ever heard. Trying to draw up an architectural drawing with a building that's standing there. So
The
that was a
architect
big
looked at
problem.
our drawings and said, he sees no problem with them drawing. That's better than most contractors do.
And if you get an architect to make up a drawing, that is undeniable, and they denied it. A licensed
All right,
architecture
well, did
drawing.
they say why they denied it?
There's a list this long.
Okay, well, we have to work on that list.
And that's stupidity.
Well, I don't know what it is, and I'm not ruling at night now, but yeah, it's the horse got behind the cart and is trying to push it. The house got built before the drawing got done. They gave you permission to
I
build
would have
it.
never
and-
built it if they wouldn't have given me a permit.
All right, I accept that. So now we're in a mess. You don't want to let it just molder away. You want to turn it into a house.
True, that's what
All
was
right,
supposed to be.
you
to
may
start
have
with.
some sort of a claim for reliance based on the township's granting the original permit. Again, you could benefit from having a real lawyer that does zoning enforcement stuff. But I'm just trying to get this case to the finish line where they can accept it, you can accept it, you can live in it. You can operate your birthing center in a different jurisdiction. Colin Township can go on to their other affairs. So can you. So I've denied your motion to set aside the default. I did not grant or deny your motion for equitable relief. I hate to say this, but it's what the answer is. You and Safe Bill need to work together to get to a solution to this problem. I don't know why it took them from October to March to look at your plan, but so there is a drawing. They've got some issues with it. It's been dropped since that point. You need to go back and try to address those issues. Mrs. Yoder?
And another thing that had been mentioned in the last hearing, also about inspection, about only the footer. So I guess we can argue that point too, because the electrical inspection was all totally, everything was fine except one spot that there was one thing that we had to change. And well, that hasn't been changed. I don't think that has been changed
No, you
yet.
can't change it because he said we gotta put something in that does not even get made anymore. And if I would make it with the one that it's there, it would be illegal. Now, I guess you explain that one.
And the electrical guy, he argued the point for 45 minutes that they, that he just, I say argued, he stood there and listened to him for like 45 minutes to being using bad language and putting down his work. But there was no there was no other inspections done.
The electrical inspector and my boy were on the phone for over a half hour. And the inspector was cussing, dropping the F-bomb and everything. And my boy, he's lucky I wasn't on the phone because I would have lost it.
Yeah.
Finally, he calmed down enough to figure out exactly what he wanted. And actually what he wanted was actually right above his head. If you would have just looked, it was right there.
All right.
May I make a comment and maybe a
Yes, I mean,
suggestion?
all this stuff is stuff I can't resolve here. Nobody's under oath. They're just expressing their frustrations. And as I said, they aren't the first person to express frustration with the building code enforcement officials. But what would you like me to know?
Well, first a comment. And I feel I had to put this on the record because, and it's been raised in other pleadings in the case. The Joders are not innocent people here. They misrepresented what they were going to build to the township in the zoning application. These are all established facts in this case. They misrepresented what they were going to build. They represented it was going to be, first it was a single family home, then it was a 2-family home. It was never represented to be a birthing center. And when it became obvious it was going to be a birthing center, then everything shut down and the building permit, stop work orders were posted, and then they continued on building as a birthing center until this court entered the default judgment, the permanent injunction. They have no choice. Now they're going to go back to use it as a residence. That's fine. That's allowed under the zoning ordinance as a suggestion, but they're not innocent people here in this process. And my suggestion is, and I will instruct Safe Bill, we'll set up a meeting where Safe Bill building official will go out and meet on site. But in order to do that, I don't know if all the no trespass signs that are that long and posted by the road, and the threats of the intimidation and threats to anybody that goes out there, including Bruce Morris that has to serve documents on the Joders. He gets threatened when he goes out there. And so that has to stop. And if that does stop and the no trespassing sign come down, I'll recommend that Safe Belt go out there, meet with them. And let's figure out what needs to be done to get the building permit issued for the residents.
Well, I agree with that 100%.
I'll comment on
All right,
that
well,
one
just
if
a
I can.
minute. You and Safe Belt need to meet to figure out what needs to be
Yeah, we
done to
will.
get your permit.
But he said we misrepresented the whole thing to start with. Listen, I had 2 acres of woods behind my barn. All right. My wife told me what she got. She said they need more room. So she called Joe. I said, I'm not cutting any of my trees until I know that building can be built there. So she called Joe from Safeville, told him what we want to do. And he says, build it as a 2-family house. The contractor that drew the building permit made the mistake and put a 1-family resident instead of a 2-family house. That's why there's a 1-family house on there.
That was just one, he came to us and he said that I'm sorry, but I made a mistake. He found his mistake. He said that one of the applications I put down as a 1-family house. And I said, well, we're not holding it against him. I mean, we can make mistakes. We put a wall in the wrong spot, move it, put it
So
where it
you
belongs.
want it as a 2-family residence?
We wanted to start with
That's
having it
what
as a
Joe told us
2-family house.
All right,
File
well,
it for
I'm not sure what you want now, but there should be a way to do it. There should be a way for you and Safe Belt to meet, and Safe Belt will say, all right, this is this, we need to change this, or this is fine, and come up with enough of an accord that you can get a building permit, build it, and get an occupancy permit.
The reason for him to say for a 2-family house, the reason that came in is because of what I'm doing. I wanted more space for myself. And so I wanted to design, I have space for myself, but also have space for my moms. And so I told him what we're doing, and I need more space for both ways. That's why we're going with a bigger building, a new building. And he said, well, you would on the most average have 1 family there with, or 1 mom with you, so call it a 2-family house.
All right,
That's
so
why I was
right
put
off
down
the
for
bat,
2.
you told them this was gonna be an
Exactly.
extension of your birthing
I
center.
wanted a house. I don't want a hospital. It's not medical. It's absolutely nothing to do with medical. I want a house of people want a home birth, a home atmosphere. So that is where we have it as a 2-family house. My belongings, my things, my space, and a space for them.
All right, well, you can't do that, at least not here.
Well,
You
we
can-
realize that part
All
now.
right, okay,
But like the thing, the
All
part
right.
what we're trying to explain is, he's saying that we misrepresented the whole thing. Well, I said, I'm not cutting any trees
all right,
until
I
I
got, yeah, and I
have
got
all my
what she said
permits.
too. She's, so some of that doesn't matter what happened in the past, because we're all stuck with it.
But he said we
All right, well,
misrepresented
so
it.
your position is we were upfront about it. I don't know. But Judge Stutsman ordered, then I ordered in the permanent injunction that you can't do it. So you want to turn it into a residence. You can do that. So let's figure out how to do it.
Exactly.
All right, you have to allow Safe Built onto the property to meet with you and your builder to say, all right, here's what we need to do. The outside is done substantially. The inside needs to get done. So that's just what needs to happen. You, your builder, and Safe Built need to meet on the site, not for fear of trespassing or execution or whatever. They can come to your property, meet with you and your builder and say, all right, let's do this, this and this. You can't do this, you can't do this. Come up with a plan you can both accept and turn it into a residence. Saying it is
It is a
easier than
residence.
doing it. But to recap, again, Mr. Thornton, if you would do a motion denying the motion to set aside the default. I have not made a ruling on the request for equitable relief. I guess I would have put in the order. The Joders are directed to facilitate and allow meeting the safe built on the property to try to come up with an acceptable building plan.
We can invite them.
Yes. And I would, who's your builder?
I'm the builder.
All right,
So
so,
the only thing I've got though is, I don't care if Safe Built wants to come out and inspect. But sitting on the road, taking videos, sitting on the road, spying, that's, no.
well,
We've
I
had that
guess at
numerous
this
times.
point,
I've
there's,
had that happen. I've seen it happen. He was seen videoing my wife.
well, I don't even know what to say. Again, I can't change anything that's already happened. I would like to bring closure to this. I'd like you to find a place where you can continue your birthing, what you call ministry, where it's accepted. More power to you. I'd like you to be able to utilize this property as a dwelling, and everybody can go on with other matters. Yes,
So, Your Honor, before you close the case, so how does this work? Can you explain it to me? How does this work? So we get a lawyer and we, want to
Well,
solve some
at
problems.
this point, well, I'm not recommending that you go out and hire a lawyer right now. I would have recommended you hired one at the start. The ship is almost in the harbor. The birthing center has been enjoined. The birthing center has been enjoined from the adjacent property. Now we're simply trying to turn that adjacent property into a dwelling with a acceptable building permit and ultimately an occupancy permit. I don't think you need a lawyer for that. However, if you get into the process and you feel you're being unfairly treated by Safe Build, at that point, you could use the benefits of an attorney who does this sort of thing. There's 16 townships and 8 municipalities in St. Joe County. That is up to 24. And I'm the judge for all 24 of them. And so I get things from Sherman Township and Fabius Township and Lockport Township and Mendon Township and City of Three Rivers, City of Sturgis, and the rules aren't all exactly the same. What is substantially the same is the Michigan Building Code, which is based on a national building code. So I would first suggest you try to meet with Safe Built and see if you can come to an agreement. If you feel that their requirements are unfair or unmanageable or not legal, at that point, you may consider talking to an attorney. But at this point, all the rulings have been made. You're complying with them. And I'd like to get this building finished. So Mr. Yoder is going to do several orders. Remember, you owe $2,449.34, not twice, just once. I didn't order any fine, and I didn't order anything in the 533 case. I simply ordered that those costs be paid in the 25040 CC case. Now, Mr. Thornton's gonna supply me with the proposed orders that I ordered here today. And when I get them, I will sign them. You can look at those. If you have any challenges, you can do it. All right, now, your request for equitable relief has not been granted or denied. So if you meet with Safe Bill and they won't let you do what you want to do, and you don't feel it's fair, you can ask for relief in the 533 case. You could benefit from an attorney, but I can't compel you to hire an attorney. I don't like when people are practicing law without a license. I think you got taken advantage of. I think you're in a much worse position than you would have been had you had real representation in this matter. I think we would have come to the same conclusion. I don't think you can operate a birthing center there. I don't think you can make a birthing center in the adjacent structure. So I think that would have happened regardless, but I still think you'd have been in a better position. All right, we'll be in recess.
John,
Yes,
so as far as finishing the building, it's classed already as finished.
say that again.
I said, you said that now as far as finishing the building, it was already last hearing, it was already classed finished.
Well, it looks to be finished on the outside. What you want to get is an occupancy permit.
He stated it's a finished building.
Because it was asked, is that building,
The building is not finished. You can't use it for your intended
Oh,
purpose.
he said,
He who?
Joe, or
well,
Lance,
it's Lance Bonneville had said that.
Oh,
the
building is finished.
I don't recall.
I don't recall that either.
Testifying that the building was finished and been determined to be in compliance with the, there's been no inspection.
No,
Couldn't.
it's not that it's up to date with safety, but from his inspection, he classed that building finished.
All right.
I guess it
Well,
is not.
if they'll give you an occupancy permit, you need to get the building permit. It isn't finished. I
It
don't.
is not. There's no trim on there. The
Yeah.
kitchen ain't done, the bathroom ain't done. there ain't
Yeah,
no
so it's
toilet
not
set.
finished. So it needs to, I don't know what he said. I don't remember
Yeah,
him
he
saying
said
that,
right
but,
there.
He said right there, he
well,
said
but
the
it
buil-
isn't finished.
He
It's
said the
recorded.
building's complete and it has no kitchen and there's the most gorgeous kitchen in there.
All right. Well, I'm sure it'll be very nice. It looks nice from the outside. I want you to finish it. I want you to get a building permit. I want you to comply with what they request. I want you to get an occupancy permit and live in it. All right, we'll be in recess.
Complete, right?
Yes.
Yeah.
Hi. Have a good night.
You too, just